This is the plaintiff, Wayne Monsky. He says the defendant rented an apartment in his house, stiffed him on the last few months' rent before moving out, and actually thinks he can get away with it. He's sorry we informed the great Houdini defendant who thinks he can just disappear and stiff him, but he's here to make him reappear and pay him the $1,794.42 he's owed. This is the defendant, Michael Johnson. He says the plaintiff is sorely mistaken because he's paid him everything he owes. The guy's crazy or something and is just fabricating numbers in his head. Talk about being greedy. Owe him money? No way. He's accused of pulling a disappearing act.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says the defendant rented an apartment in his house and skipped out without paying all the rent, but the defendant says he paid in full. It's the case of the rent's too damn inaccurate.
Douglas Wayne Monsky?
Yes.
You were suing Michael Johnson II for $1,794.42 in damages and rent and other items that you say you were damaged when your tenant, Mr. Johnson, left, according to you, abruptly without notice and without paying. Tell me what's going on.
His girlfriend, Pam, moved out in end of July, beginning of August. And I wouldn't have known other than I actually went there in the beginning of August when her uncle was moving her stuff out. So I didn't know about it. But I was there to bother Michael about mowing the lawn. He was, we had an agreement for him to mow the lawn. Even though Pam moved out in July, August timeframe, she paid for most of the rent for August and September, $775 out of $800. That's the $25 was for the mowing of the lawn and stuff like that.
But that's all of the rent. In other words, his rent's $775 because you're giving him a discount of $25 for mowing the lawn.
But he didn't mow the lawn. That's part of it. But yes, at the end of September, when the payments from Pam ran out, he called me, said he was moving out. And at that time, I told him, well, I'm going to have to show the apartment. And he said, no way, you can't show the apartment. And we bickered about it and so on for a while. And he said, well, only if I'm there and have to make arrangements through him and so on like that.
Why? Okay, but that's exactly how you must show the apartment. Only if he's, unless he says you can do it any time. That's exactly how the law gives you the right to do it. You have to make arrangements with him and give him notice, and he can't unreasonably withhold it. And all right.
And throughout October, we tried multiple times to come to agreements. He said, oh, this date, and then last second it would change. And oh, this date, last second it would change. And so in the end, all I got was one day for less than 2 hours, October 25th. Okay. So basically, I didn't get a chance to show it to...
Did anybody show interest?
I had two people look. The place was totally trashed because he was still moving out. And no, not at that time. I had over 24 people originally from the advertising to...
when did you put the advertising in?
Right away at first, and then another one like early in October.
You're suing for cost of advertising. Do you have the advertising here?
No.
Oh, no. Okay. So October wasn't paid, and then according to you, you weren't able to rent it out for November because of what you're describing, and I'll give you a chance to respond in a second, what you're describing as unreasonably withholding permission and to show the place. When did you rent it?
December 1st is when the lease started.
All right. What's going on, Mr. Johnson?
Your Honor, on January 29th, he was paid the amount of $1,054 from Pamela Heckley to close the case between both of us. He also kept $800 deposits for security for supposed damages.
But what happened? You were living there with your girlfriend. Yeah, didn't work out.
We were living there. She lived there until about mid-August.
So she moves out. Rent is paid up until September.
Yes.
And then October and November weren't paid. Now you're telling, correct?
October wasn't paid. I moved out.
Oh, before. Right. According to you moved out when?
The last day of October, 31st.
Okay. And according to him, he couldn't rent it for November, and it's your fault because you wouldn't allow him to show the place. So respond to that.
I gave him 2 months' notice that I was moving out. I gave him months' notice that I wasn't able to pay the rent for October. And
Well, that's, I mean, oh, that's big. Yeah. What do I do with that? Deposit in the bank and pay my bills? I mean, all right.
After we moved out,
I hereby declare I have no intention of paying October. Okay.
but he was paid for that when she made the deal.
Right. We're going to talk about that in a second.
Okay.
But so go ahead.
So
now it's October, and bring me through the month.
So he came 2 times while to show the apartment. One time I was there, and my witness was with me.
Come on up.
The second time I was not home, he told me that he was going to leave there. And I know that he was there because I locked both locks, the top lock and the bottom lock. When I came home, only the bottom lock was locked.
Oh, wait. When he called you, he said, I'm going in without you?
Yeah.
All right. Were you present during the first showing?
Yeah.
2 people?
Yes, I was.
And was the place a mess?
I mean, we were moving out, so there was boxes packed and stuff like that,
Right.
but it wasn't that bad.
No, the potential tenants should be able to see through that. And then, did you overhear any discussion between the two of them? I know he's your boyfriend, but...
Yeah, I heard him on the phone with him a couple of times. The times that he asked to come show the apartment, he had to work and things like that, but it wasn't being unreasonable.
Okay. And did your boyfriend tell him, I want to be there when you show my place?
Yes, he did.
All right. So that second time when he said, I'm going in anyway, why wouldn't you have told him, no, you're not?
I just didn't want to argue with him. You know, I already told him that I wasn't able to pay the rent, so it's...
Okay, so you didn't think you were in a position to argue with him?
Yeah.
All right, let me ask you a question. Apparently he sends a letter of demand, correct?
Yep.
To you and your ex saying, you folks owe me for this, 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 and this, okay? And then you're telling me that Pamela's your ex?
Yes.
Paid a bunch of money in January. This is all happening. This is November. The letter of demand is sent out. It's dated November 1st. Did you get it like a little bit after that?
Yes.
Give me the piece of paper where he demands from you two the money. I want to make sure it's the same thing I have. Okay, this is something different now. This is apparently, what is this? This is a letter to, who's Sharon Heckley?
Her mother.
Pamela's mom. That says, here's a breakdown of the current numbers per your request. Okay, first there's no date on that. When did she get it, do you know?
No idea.
All right, did you send 2 letters?
That's not a letter of demand for Sharon Heckley. She wanted a breakdown of the costs.
Well, yeah, it's unpaid rent, floor damage, October advertising, other damage, marshal service, court fees, cleanup costs, garage door opener, remote. It's the kind of stuff we're talking about.
Right, but I wasn't. She took care of all the damages and opted out of the case. And basically, so all the damages are taken care of. I now continue to pursue a case against Michael, who was the one there during the lost rent.
You have a security deposit of $800 that belongs to both him and Pamela, okay? Pamela and he are foregoing their right to the security deposit. They're like, okay, take that for damages. That's $800. Then Pamela or her mother send you a check for $1,054. Where's that in my math?
So can the tenant say, I'm not letting you show to the next tenant until I move out?
Yes, he can say that. There's a difference in what you're obligated to do and what being a nice guy would lead you.
So the landlord doesn't have to say, hey, I'll show the place for you? Or the tenant doesn't have to open the door?
Right. He doesn't have to open the door, only if he's the nice person and lets him.
Fair enough. Going inside the courtroom.
I was trying to leave Pam completely out of this by their request. And she did not pay for the rent. And I made that clear when I asked.
What was she paying for?
Okay, the damages.
Because the list that you gave Sharon, her mother, says $1,600 in unpaid rent.
Oh, yeah. I mean, she wanted to know all the numbers. So I gave her all the numbers.
You think that I should ignore the whole thing with Pamela? You settled with her, and I shouldn't take it into account. You've actually crossed it out of your statement, and that's fine. But that's not how it's done. I take that into account. When you have 2 defendants, what happens is that they're jointly and severally liable for whatever the debt is. And if they're jointly and severally liable, that means you can sue one for the whole thing, both of them for all of it, or the other one for the whole thing. What you can't do is collect twice. You can only collect what you're owed. So let's discuss a few things. You claim that part of that went to damages, and the damages that it went to are floor damage and other damage, which isn't specified. She asked you for a breakdown, you just say other damage. What is the floor damage?
Basically, where they had their couch or something, it was deeply gouged in the...
Can I see the pictures?
Yeah.
And can I see the estimate to repair it?
No, because I was going only for the rent. Okay, these are other pictures.
You Right. For reasons I've already explained, this is a case against both of them. One of them is settled out, and that's fine. But I have to, by law, take into account what you received to make sure you don't get double compensation, my friend. All right. Okay, so these are the gouges over here.
Yeah.
Right. And a door that appears to have been swelled by moisture.
No, that's a steel door.
It's a steel door, so what happened? Are you kicking the door?
That's a wood door. That's the bedroom door.
No.
Is there trouble in paradise? Did somebody take a crowbar to the bedroom door?
Nah, I was sleeping. She panicked, so she thought something was wrong. She forced
Something was
the door
wrong
open.
or something was fishy?
I'm a deep sleeper, so
Okay.
she just budged the door open. The door is already falling apart. You can't even close the door before we moved in.
So how did she get the door open with a?
She just pushed it open. It was a little lock, one of the sliding lock.
Also, he
no,
did
stop,
not.
stop.
Okay.
Okay. I've got his co-defendant paying you $1,854. And I've got you suing him for $1,794, which is less than what you've already been paid. The only difference between what you passed off to the co-defendant and what you're passing off to him is $700 in floor damage, and which you have no proof of here, and is excessive, I think, for what I'm looking at, and $130 in miscellaneous, which you also have no. One of the things that apparently she and/or he is being asked to pay for is November, which I'm not even clear you have a right to. But no matter how you slice it, I know for a fact that you have $800, which belongs to both of them, and another check for $1,054. Why are you not satisfied? Why are we not done? Why are you then suing him for $1,700 and then in essence attempting to get a double recovery? You can't do that. My verdict in this case is for the defendant.
Judge Milian rules that the plaintiff has already gotten all the money he's going to get. Everything you're entitled to, nothing more in this courtroom. What's your feeling here?
I wish I had a chance to actually say all the things, like how he didn't move out by the end of October, how he, I've got police reports and stuff like that.
You could have talked more. You could have really won your case, right?
Well, I could have certainly made some difference because November in particular, he made sure I could not rent it for that.
Yeah. All right. We just head right down this way. Okay. So step on in here. Are you satisfied how this thing comes out?
Yes, I am.
What do you think happened here?
He came completely unprepared, and he was lying about most of it.
Oh,
so
yeah. He didn't have his evidence. So what happened? Why'd your girlfriend move out?
We weren't getting along.
What'd you learn about moving in with your girlfriend?
Slower steps.
Sometimes it works. Sometimes it doesn't.
Yep.
Okay. Harvey?
So here's the deal. Everything is normally spelled out in the lease so that you should read the lease. And if the lease says that the tenant has an obligation to let the landlord show it a reasonable number of times, there is absolutely an obligation on the part of the tenant to open the door, but it's all based on the lease.